Let's go to this conversation now. The Competition Commission has welcomed the decision by the Competition Tribunal, which found the South African Police Service supplier Tsutsumani Business Enterprises guilty of excessive pricing. This contravenes the Competition Act, and this matter emanates from the complaint lodged with the Commission by the SAPS in May 2020. Let's speak now to Competition Commission's Chief Legal Counsel, Bakhe Majenge. Thank you so much for your time this evening. Give us some details briefly about the nature of this complaint by the SAPS.
Evening to you and your viewers. Essentially, we received a complaint in May 2020 from the SAPS alleging that Tsutsumani has overcharged the SAPS in the supply of face masks. So this was a bulk supply of about 500,000 face masks. So the supplier procured these masks at the price of about 17 Rand per mask and overcharged the SAPS by an amount of about 32 Rand per mask, which amounted to an excessive profit margin of about 5 million Rand.
Now, when we look at, the details coming out of, the tribunal and also the statement that was put out by the Commission, would you say that given the desperation to secure face masks at the time is what, this company exploited or made it exploit that particular crisis?
Yeah, that is absolutely correct. At the time, there was a surge in demand for face masks, and suppliers who had inventory at the time, basically, as you correctly point out, exploited the surge in demand for face masks because there was a limited supply. And in this case, we saw the supplier charging a very exorbitant markup of about 87%. The tribunal, of course, imposed a penalty of about 3.4 million, which is slightly less than the excessive profits which were earned by this supplier, but that is simply a function of the fact that the penalty calculation in terms of the Competition Act is turnover based.
What do you say then to those who are saying that is not enough because it's, as you say, it's only a fraction of what they got in excessive profits, and some are saying there should have even been more, that they should have been either fined here or possibly even refer this matter for possible criminal prosecution if you are able to do that?
The penalty imposed by the tribunal, which is a penalty of 3.4 million, is a maximum penalty that the tribunal can impose. But in addition to the penalty, the SAPS, of course, can institute a claim for civil damages to recover the 5.3 million excessive profits or the overcharge. In terms of criminal sanctions, that is a matter that will fall within the domain of the Special Investigation Unit, only if there is a finding that there was some form of fraud or corruption or some other form of malfeasance involved in this procurement process.
And when you look at the state organs, what in your view would you say makes them vulnerable to such conduct that we are seeing here?
The vulnerability in this case arose out of, as you correctly pointed out of desperation. Because there was limited supply of masks, and those suppliers who had stock or inventory then were in an advantageous position because the SAPS required the supply of about 9 million masks per month. So there was quite a huge demand for masks, and SAPS simply had to get a supply of masks wherever they could find it. So no single supplier could meet the requirements of the SAPS, which was 9 million masks per month. This is what led to these circumstances where the SAPS found itself in a position where it was overcharged by this particular supplier.
I'm listening to what you're saying, then it sounds like they were in a difficult position because no one was available to, really give them their masks at the amount that they were hoping for. But what happens then going forward with companies that find themselves in such situations, feeling like they're backed against the wall and it's a time of crisis and they are now finding inflated prices and they desperately need these particular products? So how do they even get to a point of not paying first and then getting a fine later or laying complaints later?
The circumstances in this case were unique because as you recall, this was during the time of the hard lockdown. So the situation was completely unprecedented. Even the SAPS themselves could not have planned in advance for such a huge procurement because the pandemic itself is a situation that was unprecedented. But this case does send a clear message that suppliers should not take advantage of both the state as well as consumers in circumstances of a crisis or a pandemic or an emergency. So we will certainly be reviewing other cases where there are excessive profits or markups now that the Competition Commission has secured this precedent from the Competition Tribunal.
I know you say that you are going to be doing that, but do you have any cases currently that have landed on the desks of the Commission in order to be able to start working on them? Because this is a landmark, case when it comes to the work that you've done.
Yes, that is absolutely correct. This case is quite precedent-setting because it's the first of its kind involving price gouging within the context of public procurement. So there are certainly other cases that members of the public have referred to the Competition Commission as well as the Special Investigation Unit. So we will be looking at whether or not those cases involve excessive margins or excessive profits. And where we find that there is unjustified excessive profits, we will certainly be prosecuting those cases as well.
And I'm sure even members of the public will welcome that because it really has been quite concerning what we saw play out, in the pandemic. And you're looking at, the SAPS as well. They are still having another unresolved matter when it comes to the procurement of PPE as well, which goes into the tune of just over $1 billion. So certainly a lot of concerns are rising there. But let's leave it there for now. That was the Competition Commission's Chief Legal Counsel, Bakhe Majenge. We'll have more for you after the break.